Hi, thank you for using My Court Coach. My name is Susan, and I'll be your instructor, and we will be discussing Form FL-341E, which is the form used to request an order for legal custody of children. This form is normally attached to Form FL-300, Request for Orders. If you scroll down on Form 300, you will see number 2, Child Custody, Child Visitation. And this will include legal custody as well as physical custody. And for this, you will need Form 341E. Let's look at that now. This is the joint legal custody attachment. It can be attached to a petition for dissolution, the response to a petition, but most usually it is an attachment to request for order, or if you're the responding party, to your responsive declaration to the request for order. In number 1, please specify whether you and the other party will have joint legal custody of the children. Joint legal custody is preferred in California, and there must be a very good reason if the court is not to award joint legal custody. Joint legal custody has various aspects to it. Let's look at that. Enrollment in or leaving a particular private or public school or daycare center. In other words, choice of school. Treatment such as psychiatric, psychological, or mental health counseling or therapy requires the consent of both parties. The consent of both parties is required to enroll the child in extracurricular activities. Joint consent may be required to select a doctor, a dentist, or other health professional except in an emergency. Joint legal custody encompasses a joint agreement regarding religious activities. It also requires a joint decision on out-of-country or out-of-state travel, and it may require, should you have another request, a joint decision with regard to other matters. And G gives you the space to put in the request for an order you want and the facts to support such an order. Let's look at number 3. This tells you the penalties if you do not have the consent of the other party for the matters under number 2. If you do something without the consent of the other party, you can be subject to fines, a criminal action, and change of custody orders. There are situations where it is best, or you may think it's best, for you to have the sole right to make a decision with regard to a child. If that's the case, you would check number 4, state whether you're the petitioner or the respondent, and state what records exist that only you should have access to. Otherwise, B will be the order of the court that each parent will have the right to access such records and information about the children. 5 addresses health care notification. This means each party must notify the other of the name, address, and other contact information for a treating physician or dentist. You can request that each party is authorized to take all necessary actions to protect the health and welfare of the child, including consent to emergency procedures. Lastly, you can agree or request that each party is required to administer any medication prescribed by a doctor. If you don't want A, B, or C, leave those blank. You may request the court order that each parent will be given notice by the school of any emergency and will be designated an emergency contact. 7 is neither parent may change the last name of a child without the consent of the other party. And 8 allows you to make any other request with regard to legal decisions for a child, and which party shall have the right to do that. I hope this helped you, and I wish you good luck with your further proceedings.